Hi, everyone, and welcome to today's webinar. I see that we still have people joining, so I'll give everyone a minute to get signed on while I go over a couple of housekeeping things. I'm Nicole with the San Diego Law Library, and I have here with me today our speakers, Wendy Patrick and Ed McIntyre, who will both be discussing generative AI and ethical pitfalls. I just have a couple of stuff to discuss prior to the presentation. You should have already received an email with the handout for today's class. If you did not receive an email with the handout prior to today's class, please send an email to refdesk@sdlawlibrary.org. Again, that's refdesk @sdlawlibrary.org. For those of you who are here for CLE credit, this class is for 1 hour of ethics participatory MCLE credit. We will be issuing a participatory MCLE certificate for those of you who are verified to have attended today. This might take up to 24 hours, so just check your spam or junk folder. This is also an interactive presentation, so you'll have the opportunity to pose questions for our speakers. However, we do ask that you utilize the Q&A function. And under the Q&A function, you can either ask questions with your name or anonymously, whichever you feel comfortable with, and we'll try to get to as many as we can today. Lastly, you will receive a link with a survey at the end of the presentation. We appreciate any of you who would take the time to just complete the survey and give us feedback on today's presentation. And with that, I will turn things over to our speakers.
Thank you very much, Nicole, for that great introduction.
Thanks, Nicole.
My name is Wendy Patrick, and Ed McIntyre and I are going to be your hosts through what I hope is going to be both an interesting, informative, and dare I say, entertaining hour as we talk about generative AI and ethical pitfalls. It's a great topic that's only becoming more interesting. And I say that because more practitioners are learning how to use it. I remember when it first came out, everybody had ChatGPT and wondering, well, let me just take this for a test drive. And people did that. And they were afraid to go any farther than that because of the headlines that started coming out about lawyers writing and submitting robot briefs, not looking over the work, and really having some embarrassing headlines that, kind of splashed a little bit on everybody in the profession that was using it. We've come a long way from that point, yet we are still at the point of learning how exactly generative AI, as opposed to, as we're going to talk about, so many of the other ways in which we use AI over the years, like Westlaw, Lexis, Google, how generative AI is different, and most importantly for this hour, how it intersects with existing ethical rules. That's right. Don't be on the lookout for some sort of an AI version of the ethical rules. It's the regular ethical rules that we're both going to be discussing and how we can use those rules to decide how to use AI. As with any program I give, any graphics that are included, I either took those photos myself or it is fair use under the US code. And we're going to be using a little bit of that, but we're actually going to be very substantive in the function of sort of explaining the analysis. I mean, you can look up the rules on your own. We're going to be talking more about the heavy lifting of how the use of AI implicates the text of our ethical rules, both in California and also under the ABA. And that's where we look for the ethical rules, but we also have ethical opinions, we have ABA standards, and I want to tell you right from the beginning why we list all of these areas as potential just gold mines of information for you to look through. I wouldn't be the first to have had a question that has just stumped some of my ethics colleagues. And we talk about it and think, well, there has to be a rule. There has to be an answer somewhere as to how a particular dilemma can be solved. I mean, somebody must have dealt with this before. Many of us have found ourselves asking questions like that when beginning to use AI. And one of the things, the beautiful things about search engines nowadays, you don't need anything special to be able to look at other jurisdictions, look at ethics opinions from other jurisdictions, as well as in California and under the ABA, to see if an issue has been tackled. And as I'm going to show you in a minute, our own ethics rules invite you to do exactly that. But why do I cite the ABA standards? The ABA a lot of guidelines for practitioners. Why would you look at something that's not?
Mm.
The state bar courts look and cite from those standards as well. So it only makes sense that you should be able to look, and that you should look at some of the same material and guidelines, whether they're aspirational or binding, in an area like this, that's new, that's interesting, and that can be used to try to figure out what to do in any given circumstance. So here are the sources of ethics rules we're going to be thinking about. And we're going to be covering, first and foremost, our own California rules. But I also want to say, and if anybody wants to really, I should say, impress your peers, put in the chat, don't look it up, don't Google it, put in the chat real fast the day that California joined the rest of the nation in adopting some version of the ABA model. And I'll be looking back at that. I wish I could say you got a prize if we were in person. I'd toss some candy into the audience. But suffice it to say, it was shortly pre-pandemic. And when we finally adopted our own version of the ABA model rules, we retained our individuality in some very efficient circumstances that really many lawyers appreciate. One of those is confidentiality. Ed's going to talk about that. So these are some of the places we look for the sources of the ethics rules. And in the hour we have together, we'll talk about these three things: how we use AI to enhance investigations, the professional rules, and really the bottom line and the practical takeaway of this program is that we're talking about artificial assistance. We don't turn over anything to generative AI. We can use it as a tool, as a brainstorming tool, as a search tool that can save literally hours and hours of time. And we're also going to be talking about what you discuss with your client. Okay, so let's go to the first area: how you can use AI to enhance the way you investigate your cases. Now, I'm going to date myself, although I know Ed remembers the movie, where Tom Cruise played a police detective in the pre-crime division of the police department. And many young people haven't seen this movie, but I'm often surprisingly pleased that many people have. This is Minority Report. And when somebody was thinking about committing a murder, a red ball would come out. And this one has the name of the movie star. And I remember thinking back then, wouldn't it be great if we were able to have a pre-crime division at the DA's office, so it would really cut down on our workload because we didn't have to actually wait until somebody committed a crime. That would be a much safer community. But I almost feel like the future is here to the extent that we are able to have some sort of prediction. And part of what AI does is exactly that. When you're looking at the kind of thing that really kind of grabs headlines, we talk a lot about deep fakes. How do you do the recognition? How do you know that photographs are what they purport to be? You may decide in your law practice that it is worth it to pay for some of these tools. And Ed's going to talk about what then you discuss with your client if you decide to do that. But I just wanted to show you for illustration, this was a feature, an app. This photo was taken years ago when I was teaching AI early on in its inception at a conference, just an idea of how easy it is to de-age someone. And, you know, I was talking with Ed beforehand, whether he'd heard about the fact that actors are often actively de-aged to play certain roles. Wouldn't that be great? I guess until you meet them in person. But AI is also a tool that we use in casework to make sure, authenticity-wise, that we can get over the evidentiary hurdles that we need to before we put in our own evidence, or whether or not we know we're going to object to opposing counsel putting in evidence. So there's lots of different ways that AI is being used. Okay, diving into the professional rules. Before I turn it over to Ed to just briefly describe a document that you'll have as part of your materials, an ABA opinion, I want to say one of the reasons that you should be looking at ABA opinions is our own Rule 1.0 Comment 4 invites you to do just that. It talks about the authorities that are in our own professional rules, but then it also says, although not binding, we should look at other ethical rules in California, ethics opinions, and ethics opinions, rules, and standards. Remember, I talked about those ABA standards earlier, promulgated by other jurisdictions and bar associations. So Ed, tell us a little bit about the ABA opinion. And by the way, just by way of brief introduction, you'll have both of our bios, but just quickly relevant to this program, Ed and I have both been teaching ethics for years and years. We both served on COPRAC, the State Bar Ethics Committee. We both chaired our county bar ethics committee. I mean, we've been really living and breathing legal ethics for many, many years. I think it's probably the sexiest area of law. I don't know, Ed probably thinks the same thing because we both keep doing what we're doing. But Ed, tell us a little bit about this ABA opinion that's part of the materials.
Okay, materials that hopefully all of you got are one, Wendy's article on the ABA opinion 512, a copy of ABA 512, and then also COPRAC, which Wendy just mentioned, the State Bar Statewide Committee on Professional Responsibility and Conduct, put out guidelines, not a formal opinion yet, but at least put out a set of guidelines, again, dealing with generative AI. Take a look at the ABA opinion. I'm not going to walk you through it. Obviously, you can do it on your own time. What the ABA talks about, one, there's a pretty good introduction that explains what generative AI is, and we'll spend more time on that, including a little bit of its history, how we got here. But then flags for us several of the ABA model rules that the opinion identifies as relevant to the use or abuse of generative AI. Obviously competence, communication, confidentiality, the obligations of managers and supervisors, clearly candor to a tribunal. We've all heard about the horror stories. One caveat I will mention, when you read the ABA opinion, when it talks about ABA Model Rule 1.6, the confidentiality rule, bear in mind it is different than California's 1.6 because we also have in the State Bar Act, Business and Professions Code, Section 6068E1, our own very, very narrow, very tight confidentiality provision. So just keep that in mind when you work your way through the ABA opinion. You may also want to take a look at the guidelines that COPRAC put out. Obviously, COPRAC identifies many of the very same rules that the ABA opinion 512 talks about. Wendy?
Okay, good. So the State Bar guidance, we call them best practices in progress. And part of the reason that they're guidelines in progress is just like anything else that's new, we're working through them together and making sure that we really have some good, wise, sage, solid advice to give. And it has to be in progress because there's really no other way to sort of describe the way AI is rolling out. I'm going to give you, when we get there, some creative ways you can think about using AI in your practice without running afoul of any ethical rules. I use it a lot for brainstorming, for example. You ask AI, give me 5 things that jurors care about nowadays. And a lot of different ways in which you can develop themes and theories and ideas and creative forecasting as to what may or may not happen under a particular set of facts. You're not asking it to give you anything that is citable. So there are lots of ways you can kind of have a brainstorming partner. It's probably no accident one of the forms of generative AI is called Copilot, because you don't ever want to give it the controls, but you can have that kind of a conversation. But part of the reason that we do have these best practices in progress is what you see here in the description. The word balance is key. Protecting clients and the public against, and here is why there's probably so many of you on the call, the potential to facilitate efficiency. Efficiency is an enormous part of practice, and I'll get there when I show you sort of the ethics rules that talk about that. But with efficiency comes, supervision. You talk about AI as a law clerk. Let's pretend it was a law clerk that wrote a motion, a brief. You have to file it in court pretty soon, so you're going to have to look over it and double check it. Well, how do you supervise artificial assistance? Remember, that's what I named third prong, artificial assistance. You can't mentor it. You can't be a role model for it, except to the extent that it can learn from what you enter into the prompt, which is going to talk about in terms of the confidentiality issues. But these are just some things to consider when you think through the fact that it can be an autonomous decision maker. How scary is that? We know it can play chess, and we know it can learn to beat the world's best chess player in a matter of hours, but do you really want it making decisions on your client's case? In some ways, maybe yes, if you're wading through voluminous discovery. If you're thinking about what would be more persuasive to a jury, maybe you want to use your own legitimate experience and life experience to make that call. Okay, so part of the reason we say best practices in progress is the duty of competence is always going to be front and center when you talk about how you should use AI. However, should it go beyond simply being in compliance with what it currently says regarding technology being a portion of competence, which actually is in the rule now? Should there be something in there specifically about AI? Are we going to cross a bridge at some point where we require practitioners to be proficient in how to use AI? So that's going to be an interesting part of the noticing how the process continues to unfold. This is what Ed was talking about in terms of the practical guidance. And you're going to have this as materials. I'll let you read this on your own. But suffice it to say, they have really looked at a couple of areas that probably explain why you're watching this program today. There are unique challenges present with generative AI, different than you would face if you were simply using Westlaw. And I'm going to let Ed go into that a little more detail after I cue it up here. And many people, even when they use generative AI on a regular basis, if they were to take the stand as an expert witness, probably couldn't describe exactly how it works. Now, many of you feel like that in general. That's why you take your car to the dealership to get something fixed, or you probably don't. You probably go to an off-label garage, but you don't get under the hood yourself unless you can explain why something broke and how it works. Now, if not everybody on the call is a mechanic, do you feel as competent about explaining exactly how generative AI is able to, in a couple of seconds, come up with an answer to something that has just required it to search the entire internet? Well, that's going to be something we need to at least know a little bit more about, no doubt, as we go through iterations of different types of AI, because that's going to be a part of the duty of competence. Okay, best practices. Here's what our rule actually says. It talks about a lawyer shall not intentionally, recklessly, gross negligence. Okay, we know what the competence rule says, and it's been substantially the same in many states, at least with that prong. Here is what we normally think about when we think about competence: knowledge, learning, skill. Here, by the way, just as a point of interest, this prong, subdivision 2, is not found under the ABA or many other states. We have this specific only in California. We must have the mental, emotional, and physical ability reasonably necessary for performing services. That's an interesting aside. I would probably talk a lot more about that if I were giving a competency program. But here's where our ability to become proficient with generative AI really fits into the rule of competence as it's currently worded. If we don't know how to use it, we can get up to speed. Or we can associate somebody in that does know how to use it and is up to speed. So there are different ways that we can become competent. But here is what is relevant to today's presentation when it comes to knowing how to use AI. We have a duty to keep abreast of changes in the law, including, and here it comes, the benefits and the risks associated with relevant technology. So Ed, at this point, let's cue up a little bit more. What are sort of the most basic risks that are included within using generative AI? And maybe, you can do a contrast between generative AI and what we've been doing for years, doing Westlaw searches, for example.
Okay. Yeah, we're going to talk about two elements. One, benefits, which are essentially efficiency. And for those who bill clients based on time or time and materials, if one can perform a task a lot more efficiently, obviously the benefit goes toward the client. For those who are also just overwhelmed in their practice, to the extent that one can move through a practice more efficiently, the lawyer benefits. but there are risks associated. There are risks obviously associated with the use of any technology, but there are risks in particular associated with generative AI. And at some point, if we have the time, we can even walk through the history of how we got here. But a couple of things to understand about the AI that we've been using. If I go on to Westlaw or Lexis and I type in a query, give me all Ninth Circuit cases that involve ethics and communication, something as sweepingly broad as that. My screen will populate with who knows how many cases, some with greater or lesser relevance, but at least the magic words will be there. It's up to me now to go through and do it. If, however, I use a platform, and I'll use ChatGPT as the one I'm going to talk about the most. There are lots and lots of platforms out there, and I'll mention a couple, but this is only as a primer because right now there's probably somebody sitting in his or her office or bedroom developing the newest platform that's going to come out tomorrow. But we've got Bard at Microsoft, we've got Llama at Meta, Gemini at Google, DALL-E, DALL-E, and a whole bunch of others. Wendy mentioned a couple. In any event, if I use ChatGPT to do that very same search, give me Ninth Circuit cases that involve ethics and communication, what happens? Because of the nature of generative AI, my search now becomes part of the large language model, the LLM, that is now part of the database of ChatGPT. In other words, I have lost it. When I go into Westlaw or Lexis, it doesn't keep my query, it just responds with more or less relevant cases. However, if I put that same query into ChatGPT, it will respond. We'll get to how well it may respond. But I have now lost control over what I put in. So one of the risks, and we're going to talk about this hopefully even a little bit more when we get to talk about confidentiality, but one of the huge risks is if I put in any information related to a client that necessarily under California 6068 E1 is confidential, I have just essentially violated the confidentiality rule in California 1.6 because I have now disclosed without the client's informed consent, unless the client gives that informed consent, I have now disclosed client confidential information that is out there in the universe, could be used and show up in somebody else's response. So that's just one of the risks of using ChatGPT. One of the others, and we've all read about the horror stories. The Avianca case, there's also the Michael Cohen case, there's a recent case out of Texas, there's a recent case out of Utah. I'll touch on Avianca because this lawyer was literally felony stupid. Lawyer is representing a plaintiff who was injured in an Avianca flight. He sues in state court in New York. Obviously, Avianca removes it to federal court and pleads the Montreal International Aviation Treaty. The lawyer's law firm had let its subscription to federal databases lapse, so the only available database for research for him was New York state law. He also wasn't even admitted to practice in the Southern District of New York, which is where the case was removed to, but one of his law partners was. And then his teenage son said, "Oh, Dad, there's this great new search tool called ChatGPT." And he used it, and it gave him just a wealth of cases, beautiful citations. When he queried it again, it gave him the names of the judges. It gave him, quote, who wrote the opinions. It gave him quotes from the opinions. This all goes into a brief. A query comes back from the judge who says, my law clerk is having a lot of difficulty finding these cases. Can you get them for us? And meanwhile, opposing Avianca's lawyers are saying the same thing. So he goes back and queries ChatGPT again. Are these cases for real? And they assure him they're for real, and they give him even more substance, more quotes from the cases. Well, obviously, it turns out these are what is affectionately known now in the parlance as hallucinations. In other words, your computer's on drugs. But none of these cases existed. There was an order to show cause why he shouldn't be sanctioned. A colleague of mine in New York, we both belong to the same ethics professional responsibility association, represented this lawyer in the Southern District of New York. And his plea to the judge was, this lawyer has been so vilified in the public press and the professional press, he really shouldn't be sanctioned any further. And it kind of worked. The sanctions were only $5,000, which in the circumstances was relatively modest. So there's the 3.3 obligation of candor to the tribunal. Now, in this instance, to cite two cases that you haven't even looked at is, as I said, felony stupid. Nobody would do that. Let's hope. Well, he did it, but most of us, we hope, would not do that. Nonetheless, one of the real risks of using generative AI, not only the confidentiality risk, but also the error risk, the hallucination risk, if one is going to file anything with a court that is the result of research on it, because it could be wrong. There are a couple of districts and some district judges that are now making lawyers represent whether, in fact, for their filings, they have used generative AI in their research or in any of the preparation of filings. And there's at least one district court, I believe in Utah, where the judge forbids lawyers practicing in front of him to use generative AI, which, frankly, goes probably a bridge too far. But it's the way some of the courts are trying to deal with this now. But they are just some of the risks associated with it. The obvious benefit is the benefit of efficiency, which, translates from the client's standpoint into lower cost. We are very, very concerned in the state bar right now with providing services to those who really can't afford it or who only can minimally afford it. Obviously, to the extent that we can make the delivery of legal services more efficient, a greater population will then enjoy, some of the benefits of legal representation, which is obviously a public benefit and also, frankly, a benefit for the courts, who really just prefer that they deal with lawyers and not deal with people in pro per. But there's a bit of a primer on it, Wendy, and if we have time, we can get a little bit more into confidentiality.
Yeah, we definitely will get to confidentiality. I want to pick up on something fascinating that Ed said. And thank you, Ed. That's phenomenal information, very practical information.
By the way, Wendy, we have a winner. I don't know whether you're looking at the Q&A. But yeah, somebody did pick. It's 11/1/2018 is the date that we joined the rest of the country. And
I saw that
adopted some version of the ABA model rules.
Anonymous attendee, so nobody wanted to take credit for that, but you're right.
Yeah.
Since we're in the Q&A, and this actually fits right into what you were just saying, Ed. Oh, Olga Garrow is the winner. Congratulations, Olga.
Olga, you win.
You win. A virtual piece of candy. It's got no carbs and no calories, so that's a benefit. So another interesting question that I was looking at in the Q&A, does using Grammarly fall into the AI precautions warnings when proofreading motions? Well, and I'll let Ed weigh in too. Grammarly's not creating content for you. However, I always like to try to play the edge. What if there was to be an argument that autofill, you know how sometimes when you're speaking into your phone and it changes words for you and you think to yourself, how could you possibly think that's what I was trying to say? Might there be, and Grammarly is a pretty good program, but I don't know, it's not really the same thing, but you can imagine how it tries to be helpful. sort of in the same way that AI tries to be helpful. But I'm not aware in courts that don't require you to use to state whether you've used generative AI, you wouldn't be required to say you used Grammarly. Ed, do you disagree? I know you were talking about those fascinating federal examples.
Yeah, no, I agree with you. Grammarly is not generating content the same way that generative AI is, which is working on a predictive model. And I look at Grammarly almost as the way Word will highlight a misspelling and give suggested corrective spellings, sometimes weird ones, sometimes correct ones. So it's simply a tool to be used.
But it was a great example. So
Grammarly is a very good example. Yeah.
Yeah, I wanted to pick up on something Ed gave as an example too, about how there is at least one judge that forbids lawyers from using AI. Ed and I were both teaching ethics and writing ethics opinions at the local bar and at the state bar on social media and researching jurors, for example. And there were cases where judges in certain jurisdictions wouldn't allow lawyers to Google jurors as they were doing voir dire to try to figure out who did or didn't write letters to the editor or whatever else, because it wasn't fair, because one side had a computer, the other didn't. The pendulum has completely swung on that type of thing, where nowadays you see judges saying, wait a minute, do you guys not have Westlaw Lexis back at the office? Are not able to do a legitimate ethics and effective search on the parties beforehand? In other words, we're almost expected to have a level of competence to research not only the triers of fact we're picking, but every other aspect of our case. So I just find it interesting that today there are some judges that forbid lawyers from using a tool that may in fact be viewed as a part of the duty of competence in the future. Because let's face it, technology, that word is already there. So whether or not there is an addendum that says technology includes the use of generative AI or similar programs remains to be seen. But it's great analysis. Okay. So I'm going to give you a couple of other ideas as to why you might think about using generative AI in your cases. Now, there are ways to do searches that is not creating content, and you may already have excellent search features. But there are also reasons and things that you want to do that does involve some level of creating content. And, whether or not you still use paper, whether you've gone paperless, you don't want to have an office looking like this. We have the need for speed when it comes to client cases, because we also have to comply with Rule 1.3, which is the duty of diligence. So just think about the difference in being a lawyer that knows how to safely and ethically use generative AI, how quickly you would be able to complete a matter for a client and thus probably bill them a lot less than a lawyer that doesn't know how to use it and is spending needless hours where they could have delegated something non-controversial to some kind of an AI program to do it for them. Now, obviously, finding that program and knowing how to use it, that's different. But the duty of diligence basically says we have to figure out how to do our jobs better, faster, so we don't miss deadlines. And here's the way it's phrased. We shall not intentionally, repeatedly, recklessly, or with gross negligence. That's the exact same language you just saw in Rule 1.1. Fail to act with reasonable diligence in representing a client. So what's reasonable today may not necessarily be reasonable tomorrow. When I started practicing in the late 90s, it was reasonable to have writing pens and a good-sized yellow pad of paper before you went to court. The only thing that may have been undiligent or incompetent was to not have enough pages left or to have a pen that was going to run out of ink. Fast forward to today. Diligence and competence mean far different practice pointers than they did back then. And we're only talking about the span of 30 years. We are exponentially expanding with things like AI, being able to do our jobs quicker and faster. So diligence is another rule of professional conduct that comes up. And it's a good thing that the word reasonable is in there, because it is defined a little bit more broadly than simply the always be closing trailer with Alec Baldwin. We don't need to have diligence that is unreasonable because we can only do so many things at once, but it means that we act with commitment and dedication to the interests of the client. We don't neglect a case, we don't disregard, we don't unduly delay a legal matter that we're handling. So I wonder whether there might be an argument in the future that a failure to take advantage of being able to work faster and more efficiently for a client by safely knowing how to use AI might be viewed as a violation of 1.3. Just tossing it out there. And when it comes to knowing how AI works, and Ed, you may want to weigh on this when I give a couple of examples in just a minute. But one of the things we all tinkered around with was ChatGPT. That's a limited data set. It doesn't give you today's practice pointers or today's news of the day up to date because it's not immediately connected to the internet unless you buy the enhanced service. There are lots of different types of AI that work the same. In other words, they don't have live access to the internet. They're going to give you data that was valid through 2001 or whatever it was. So you have to know which type of AI is only going to have access to a limited data set. And the date restriction, ChatGPT, that's the prime example of that. You also wonder who programmed your AI. We have heard horror stories about biased information in, biased information out. And the last thing we want to do nowadays is be using a search engine that is going to slant the way it delivers information for you. Because if you are called out on it and you do have a judge that maybe originally didn't require you to share whether or not you're using AI, I got news for you. You're going to be asked that question if there's any indication that you are not giving the best information. Now, if you're just using it to brainstorm, that can also be a problem because you are still going to some extent to be relying on whatever it is that you are using. So keep that in mind also. And then, of course, we talk a little bit about double checking the work. And that also has an implication of an unauthorized practice of law. So I, like many of you, watched every AI legal presentation that was hitting the internet back in the day when this was first coming out. And I still remember that one of the issues that was coming up repeatedly was the duty to supervise, because otherwise there was a question about, well, where do you cross the line into AI actually practicing law? But obviously what we are suggesting is that it not be delegated the practice of law, legal analysis in any aspect, but it can be used for plenty of other types of things. And Ed, if you want to weigh in on a little bit about this distinction here as well too.
Okay. I mean, let's talk about and get some understanding of what generative AI does so that we can understand, as Wendy said, some of its benefits, but also some of its risks. When I go into, and I'll use my same example of Westlaw. I go into Westlaw and I ask it for cases in the Ninth Circuit that deal with ethics and communication. It's going to give me answers to my question. Or not, depending on how artfully I pose my query. If there are no cases, it will come back with, there are no cases, and I'm going to have to modify my query. Generative AI is basically like a puppy. It wants to please. It is programmed to please. I mean, to take Wendy's point, know who and how your AI is programmed. If it is generative AI, it is necessarily programmed to please. It will give you an answer, whether it's a correct answer, reasonably correct answer, or total BS, it will give you an answer. And if you hit the regenerate part of it, it will give you another answer that may be BS piled higher. It's just the nature of the beast. The other thing about it, and this is bias, and it comes to obviously Rule 8.4.1 bias, in order to create the data set, this humongous data set, they had to sweep just about everything that exists, which is why the New York Times, a lot of other publications are now suing OpenAI because it scarfed up all of its copyrighted material and just included it in the data set. And it's trying to get away with saying it's fair use. Fair use to run a billion-dollar company? Hardly. In any event, it scarfed up everything on the internet, everything in social media, everything back to the beginning of the printed word up to 2021, which was the most recent cutoff, as far as I remember, of generative AI, of ChatGPT, which means it scarfed up all the crap that's on social media, which has, all sorts of bias in it, misogynistic material, anti-gay material, just everything, and racist material. It's all packed in there. That is, again, one of the risks and one of the biases that one has to be aware of in using generative AI. The other part of it is, when I go into standard AI, or even if I'm using TAR, technology-assisted review for a big data set of documents, say a terabyte or 3 or 4 of documents, it's not going to predict anything. It's going to answer a question. How many cases are there in the Ninth Circuit based on my query? How many documents in here were generated by a lawyer that might be therefore subject to attorney-client privilege? That's not how generative AI works. It is essentially predictive. It's programmed essentially just to statistically determine, based on this humongous data set, what is the next word, sentence, and paragraph that would, based on all I know, all I have, would follow from the word before, which means it's really terrible at doing math, because math is not predictive. If I want to know how much is 2 plus 2, it's not, well, it's somewhere between 3 and no greater than 6. No, 2 plus 2, there is an answer. There is only one answer. There's one factual answer. That's not generative AI. So one, it has scarfed up everything in the internet, in the universe, and it's programmed to be a puppy. So it's programmed to respond, and it is programmed to be predictive, not to answer your question, but to tell you statistically, this is what probably should work. Now, I've played with it. I've gone in and said, okay, give me a letter from a lawyer to a client, first-time client, explaining attorney-client privilege, talk about speed. In 3 milliseconds, my screen filled, 2 full pages on a laptop, and it wasn't bad. You'd never send it to a client without editing it and tweaking it a bit, but it was a pretty good explanation, basically, of the attorney-client privilege. I hit regenerate, boom, even better. Case citations in there. Let's hope they were real cases. One would presumably go and check. Hit it a 3rd time and it was fine. Just for kicks and giggles, I said, do a letter from a client to a lawyer complaining about a bill. And the first letter that came up, again in milliseconds, first letter came up was, dear lawyer, there must be some mistake. Regenerate it, a little stronger. 3rd time round, it was pretty irate. I mean, it really did a very, very nice job. It was a lot of fun just to play with. But, when it really comes to using it in our practice, we've got to, one, understand it and what it's done and where it's come from and how it differs from any other kind of artificial intelligence we've used up till now, understand its biases, but also its huge benefits. Wendy talked about, will we ultimately be required to use it? I think under Rule 1.4, communication with a client, obviously, if you or your law firm is using generative AI, I think there's an obligation to inform the client and discuss with the client, these are the benefits, speed, efficiency, these are the risks, confidentiality. If I'm not using generative AI, do I have an obligation under 1.4 and 1.5, billing clients, to also discuss with the client, I'm not using it. Is this something that I should, at least on your work, consider learning and using because of the benefits, but also because of the risks? It seems to be that we are getting to the point where we've got that obligation of communication with the client going both ways. If I'm using it, yes, I think there's a clear obligation to communicate that because it is clearly a new development in the representation, substantially new development in the representation. But even if I'm not, because it's now reaching, it's hard to call it mature, but at least it's no longer a baby. It's, sort of reaching maybe adolescence and becoming more and more trustworthy. There is probably an obligation also, to explain to the client that I'm not using it, but maybe you want me to. There are a couple of the elements. There's one question that I'd really like to touch on it because I think it is excellent and there is no answer to it. One of our attendees used a free version of an AI tool for legal research representing a impoverished consumer client.
Nonprofit.
And then found out afterwards that buying the program was so expensive that her organization could not afford it. Is the bar, either state bar, local bars, trying to do anything to help lawyers in those kinds of situations, working for public benefit corporations, get these tools in order to confer the benefits on clients? To my knowledge, at the moment, the answer is I do not believe so, but I think it is an excellent question and clearly something that probably ought to go before the Board of Trustees, that at least somehow or other it gives some consideration to it, both the State Bar Board of Trustees and maybe the SDCBA Board of Trustees, to see if there is some way to do it. Regrettably, because of the dealing with the legislature, the State Bar, at this point, if you look at its financial statements, is being underfunded. So I'm not sure it would have the ability to underwrite the use of this kind of material. Whether any of the companies, for PR purposes or otherwise, would want to underwrite its use for, not-for-profit public benefit corporations providing free legal services or low-cost legal services would be another interesting question. So, but it was an excellent question. Thank you very much.
It's also
anonymous, whoever you are.
Yeah, it's also a great question because think about what the cost was of so many other programs when they first came out. Competition may drive down those overhead costs of using things like generative AI because there's just more and more to choose from, and more are going to be offering these, get a year free if you buy 2 years. There's just a lot of things in the works that sort of mirror the ways in which other types of things have been funded by local or state bars. I'm thinking about money to hire expert witnesses, for example. There's lots of specialized knowledge, and now we're talking technology that goes into representation that needs to be updated. So yes, the more these things are brought up, and people on these panels, whether there's the money, I suppose, is a different issue, but I think there'll be consensus that it really becomes necessary. And think about it this way: if we actually do specifically work towards this idea of competence in practicing law, including the use of generative AI, then there has to be a solution to being able to fund lawyers to provide this, its use to their clients in preparing a case. I want to pick up on something Ed was bringing up too, since we tend to sort of think about AI we personify it in a sense. Ed says it's a puppy dog, it wants to please. I've had colleagues that have been working on different types of projects in the legal community and even beyond the legal community that have asked AI, write this letter from the perspective of being angry. I had one that said, write this letter from the perspective of being under the influence, and got a result. that was pretty good. And you think AI's never been alive, never been under the influence of anything, never felt an emotion, never been angry. So that gives you some idea as to the scope of information that it draws from. But it also lets you know that if you were to ask it something like that and receive a result that seems biased in any fashion, remember, and Ed cited this earlier, 8.4.1, we've got this duty not to engage in any kind of discrimination in any part of our practicing law, whether it's hiring, firing, preparing a client's case. So we always want to know as much as we possibly can about where AI is getting the information, which is also why this prong of the COPRAC practical guidance is also important. You'll notice here it references both rules 1.1 and 1.3, and it really gives us the idea that there can be a tendency to over-rely on AI. And one of the practical reasons we might do that is our time is so precious and limited. We may not have time to meticulously do all of these different types of chores or tasks or things that we might otherwise delegate to a law clerk. Maybe we don't have a law clerk. Maybe we can't pay a law clerk. And there's just this tendency to over delegate to AI. And that is something we have to continually struggle against. So we make sure we don't over rely on AI to such a degree that it is pervading the area of legal analysis that obviously we cannot delegate under any circumstances. So this goes on. I think we're going to.
We have another question, Wendy. I think this might be an appropriate place to address it. Tips for a new solo using AI as a virtual assistant and any ethical issues. And since you just mentioned the duty of supervision, if, as I understand the question, using AI simply as a virtual assistant, and I wrote an article several years ago on this topic where I created St. George. I named my virtual assistant AI. But the one that I can think of is 5.1 and 5.3, the duty to supervise both lawyer and non-lawyer personnel, and think of, in this circumstance, AI as a non-lawyer virtual assistant. I mean, you again are going to have the ethical obligation to make sure that what you are relying on it for is accurate and is kept confidential. So it's got to have a scope that only you have access to it. It has access to nothing else. If, as I understand it, a virtual assistant, if this is what's keeping my calendar, updating my appointments, those kinds of things, obviously there's no issue with it so long as I supervise it. If it's interlinked with other users or possible users, then obviously there's a confidentiality issue, because if I have an assistant, a human being sitting somewhere, I could say to him or her, this is confidential and you have to keep it confidential. You can't really say that to AI. So that would be another area of policing. But I think, again, for a new solo, as Wendy said, it presents some really great opportunities to run your practice to make it more efficient. But these are the does the paid version of AI keep client confidential? No, it does not. Simply because the nature of generative AI is that everything that goes into it becomes part of the large language model, the data set that it's using to teach itself. Remember, generative AI is essentially underpinned by neural networks, a series of algorithms such that theoretically mimic the human brain. They learn by trial and error, mistake, better, there it is. So pretty much the same way a child learns. And in order to continue to learn, it needs new data that it can respond to. And that's why everything that goes in becomes part of the the large language model, the data set that it's using literally to learn from. So it's, it is essentially a neural network. Much of the early work in neural networks, as a matter of fact, was done here in San Diego by some scientists. But that's why, there ain't nothing that's confidential in generative AI. So.
No, this is good. And, in the interest of just sort of seeing if we have any final thoughts or questions, part of why we want to teach this is, this is something that can be a game changer in some respects in practicing law. But our calling is, like my medical friends always say, do no harm. Well, we have the same mandate, and we really want to make sure that we're using it not just to foster our own best interest in being able to work faster, but also in the best interest of our clients. So let's see if we have any maybe final questions we can pick up. You guys, these are great questions that you've been asking.
Yeah, they were excellent questions. And good. Yeah, let me echo what Wendy said. I mean, it is a tool like any other tool to be used for the benefit of our clients and ultimately the benefit of the public generally, including the court system. So to the extent that it is a tool that we can use, it's, I'm of the opinion that it's a tool then that we probably have an obligation to use. At the same time, like any tool, it has its downsides, and we have to be aware of them and avoid them. So AI is never HIPAA compliant. Apparently not. No. Most reliable, efficient AI tools for lawyers. That's a tough question. I don't know enough about it to give you a solid answer, but let me talk to an expert friend, lawyer of mine, and see if he has one or two tools that he would recommend. If so, I will pass it on, and presumably it can be then communicated by email out to everybody who is attending. It's part of the subsection of the Competence Rule 1.1. If you don't know, go and engage another lawyer who you reasonably believe is knowledgeable. And that's exactly what I'm going to do to answer that question.
I see someone's also weighed in saying Lexis AI and Westlaw Precision are solid legal AI. I agree that those are great tools. Generative AI is a little bit different than using a search feature. When it comes to generative AI, one thing I want to leave you with is the idea that practice makes perfect. Ed gave the example of asking for 3 client letters, and they got progressively, I don't want to say angrier, but more forceful. I have found that the more you use it and you see the way in which it's able to do things differently, you gain the experience that will help you make a legitimate, intelligent decision as to what to use it for. And I find that analysis can be very persuasive. If, God forbid, you're ever asked by a judge why you used a particular area, you can talk about the extent to which you've become competent or proficient in whatever it is you're using. Now, if you're being asked by a judge, I have a feeling maybe you're citing it when you shouldn't have used it for citations. But if you're simply using it as a brainstorming tool, I've met some people that prefer different kinds of programs, again, with generative AI, not just doing searches, because they simply like the way in which they're able to interact with it better. For example, if you're thinking about, give me 10 good questions to cross-examine an expert witness. You don't give any case facts. It's just very vanilla. It could be any expert witness on any topic. And then if you ask it again the next day, first if you hit regenerate, you'll get different answers. But if you wait and ask it again, it'll improve itself in a day, in a week, in a month, and you'll have an entirely better set of answers.
Wendy, let me go back to, it's an excellent point, Wendy. Let me go back to that question of the new solo practitioner. Okay, I grew up in 3 firms, Deckard, Price & Rowe, now Deckard back in the East Coast, Gray Carey here in San Diego, and then Solomon Ward. As a young lawyer, one of the advantages I had in those firms was I was surrounded by other smart lawyers that, I could go and pick their brains or just bounce a question off them. If I'm sitting alone as a new solo, you might find genuine use in using some of these interactive, participatory, generative AI programs, simply as Wendy said, for brainstorming, to get ideas. You're not going to reveal anything because they're not going to be, you're not giving away client secrets or client information. But it kind of fills the void that, I did not have in my life. I had real live lawyers to whom I could go, or, meet in a bar and, discuss problems and issues and cases. Fortunately, those lawyers were bound by confidentiality. Your AI, your generative AI is not. But bearing that in mind, it could be a very, very useful tool for brainstorming and coming up with ideas. What are 10 good questions to ask an expert witness? It's, I guess the first question is, did you really do all this work yourself, sir? Yeah.
Yeah. Well, thank you all for attending. We're at the end of the hour, but this has been phenomenal. I wish we were there in person, but I want to thank you for the great questions. I want to thank you for everybody that logs on, and I hope we're able to update this program in the future as more information becomes available. So thank you very much, and best of luck to each of you. Nicole?
Thank you all.
Thank you, everyone, for joining. Thank you to our speakers, Ed and Wendy, for such an amazing presentation. Like I said, if you guys can take time to fill out the survey at the end of this Zoom. But thank you all to attending, and thank you for our wonderful speakers.
Thank you.
Yep.